Welcome to Dialogue. This is a conversation that's, well, it's a necessary one. We're continuing our series looking into the Jeffrey Epstein case.
Right.
And today, our focus is really specific. We're honing in on what can only be called the initial legal failures. We're talking about that critical window between 2005 and 2008.
And that time frame, is probably the most important part of the whole story. It's really where the system we all expect to work.
The one that's supposed to be blind to wealth and power.
Exactly. It's where that system was confronted with overwhelming evidence and, well, it bent. And you could argue it completely broke.
So that's our mission for this deep dive.
Yeah.
I want to unpack piece by piece how it happened. I mean, the Palm Beach police had uncovered this massive organized criminal operation.
No question about it.
And yet a full federal prosecution was, it seems, systematically avoided.
Circumvented is the word. You're looking at a textbook case of institutional vulnerability meeting, an unparalleled level of elite influence. The normal expectation is law enforcement finds something this big, the system just moves forward.
Inexorably, yeah.
But the reality was so different. What we see in the sources is that the system hit a wall of resistance. It just wasn't equipped or maybe even culturally willing to push through. Those 3 years are, I think, a crucial case study.
A case study in what exactly?
How the justice system's biggest weaknesses are exposed when someone with that much money and that much political capital decides to exploit them.
Okay, so let's start where it all began. At the local level, in Palm Beach, the police investigation starts in 2005.
Right.
And the evidence they were gathering, it wasn't ambiguous, it was damning.
It was incredibly strong. The detectives in Palm Beach, according to all the material we have, they built a really robust case. They did the work.
They did the hard work.
The really hard work. They were securing victim testimony, which is emotionally draining and difficult, gathering physical evidence and establishing a clear pattern of criminal behavior. It was all there.
So the straightforward expectation is, okay, you have this airtight case, you see evidence of interstate activity, you hand it up the chain for federal prosecution.
Right. That's what should have happened. But it didn't. What followed was this immediate, intense battle.
And the resistance they faced, it's been described by the people who were actually there as fighting against gravity.
That phrase is just perfect, isn't it? It perfectly captures it. Imagine you're a detective in a small police department. You have a limited budget, limited resources.
Sure.
And suddenly you are up against what was essentially a private army of some of the most high-powered lawyers and investigators in the country. The minute that investigation went public, this chain of failures, or maybe a better word is accommodations, it just began.
So let's get specific about those obstacles. This wasn't just a lawyer saying, my client pleads the fifth. The sources point to active, deliberate obstruction.
Oh, it was active. That's the key distinction. It was deployed immediately. Epstein's legal team, which was incredibly sophisticated, they just went on the attack. Procedural delays, constant challenges to search warrants, filing motions that, weren't really designed to win on legal merit. They were designed to bury the local prosecutors in paperwork.
To bleed them dry.
Exactly. Bleed their time, their money, their resources. It's a war of attrition.
And beyond the legal games, there was something darker. The use of private investigators.
Yes. And that is where you cross a line from standard legal defense into something else entirely.
Intimidation.
Active witness intimidation. You have these PIs who are leveraging fear, maybe financial threats, threatening to expose personal details about the victims or their families. You're not just defending your client anymore. You're actively trying to dismantle the case by silencing the witnesses.
And we're talking about minor victims, which makes that tactic even more
heinous. It makes the job for the detectives exponentially harder. Instead of just building their case, they're now spending half their time reassuring and protecting their own witnesses.
Did that pressure stay external? Or did it start to seep into the system itself?
It became internal almost immediately. You had this external pressure from politically connected people to, maybe reduce the charges, to look the other way. But the most insidious tactic, I think, was the scrutiny. This unusual and completely unfair level of scrutiny that was applied not to Epstein, the suspect, but to the victims.
That's a classic strategy, isn't it? The inversion of scrutiny. You attack the credibility of the accusers so you don't have to defend the actions of the accused.
It is, and it's a strategy rooted in class and reputation. You take these victims, many of them young, from less privileged backgrounds, and you put their entire lives under a microscope.
You're signaling to the system, these people aren't credible.
Precisely. Their stories are exaggerated, they have ulterior motives, And it works. It creates an environment where the investigators suddenly feel like they have to defend the victim's character as much as they're prosecuting the suspect's crimes.
They're constantly on the back foot.
Constantly, justifying their own witnesses' credibility over and over again. It wastes time. It wears them down.
And all of this pressure, this massive resource gap, it all lands on the state attorney's office.
Right. And they look up and see this legal dream team or nightmare team, depending on your perspective, staring back at them.
And the names on that team were just staggering for a local case.
I mean, you're talking about Alan Dershowitz, Ken Starr, Jay Lefkowitz, Gerald Lefcourt. These are not your average defense attorneys. These are heavy hitters.
People with deep connections in law, in politics, at the highest levels.
And bringing that kind of firepower to a state-level case sends a very clear message.
The message being, we will outspend you, we will outmaneuver you, and we will make this so painful that you will give up.
That's it exactly. Their strategy was relentless. It wasn't just about winning a trial. It was about making sure a real trial never happened.
So a multi-pronged attack. What was the first prong?
First, attack the credibility of the minor victims. Do it in the press, do it in private meetings with the prosecutors. Just sow doubt constantly.
And the second?
The threat of litigation. Massive litigation. Not just against the prosecutors, but against any institution, any local government body, maybe even the media, if they reported on it unfavorably.
It's psychological warfare. You make anyone who might cooperate with the investigation think twice because they can't afford a legal battle with a billionaire.
Right. And the third prong, and this is maybe the most important one, was leveraging all those social and political connections.
This is where they tried to rebrand him.
Correct. This wasn't just a legal defense, it was a PR campaign. They were actively redefining Jeffrey Epstein in the public and private sphere. He's not a predator, he's a philanthropist.
A friend to scientists, a donor to universities.
A respected member of society who dines with senators and presidents. And that framing is incredibly effective.
Why? What does that do to a prosecutor's mindset?
It creates this profound perception gap. It makes prosecuting him feel risky. It feels like you're not just attacking one man, you're attacking the establishment he's a part of. How could this generous, well-connected man possibly be guilty of something so sordid?
And the sources say the state attorney's office just appeared overwhelmed and uncertain.
And that uncertainty is the crack in the armor that the defense was aiming for the whole time. They didn't need to win in court. They just needed to create enough doubt, enough chaos, enough political pressure to stall the local prosecution.
Because when a prosecutor's office is exhausted and worried about the cost, a compromise starts to look very appealing.
Very appealing. The goal was to either force a favorable plea deal or, even better, to get the whole thing kicked up to the federal level where they felt they had even deeper leverage.
So the local battle was a success for the defense. It completely gummed up the works and paved the way for the feds to step in.
Exactly.
Which brings us to federal involvement. The FBI steps in, and that should have been the moment things got serious for Epstein. Why was their involvement such a game changer, legally speaking?
Well, it's a crucial distinction. State crimes happen within a state's borders, but the federal government's jurisdiction kicks in when a crime crosses state lines.
And the FBI has the resources to investigate that.
They do, and they quickly found evidence of multiple victims who had been transported from one state to another, from New York to Florida, for example.
So the instant they established that he was moving victims cross state lines.
It provided a clear, undeniable legal basis for federal sex trafficking charges, and those charges are a whole different world.
We're talking about much harsher penalties.
Much harsher. Significant mandatory minimum sentences. The kind of charges the state of Florida couldn't bring at the time. This is no longer a local issue. It was a federal criminal enterprise.
So the system should have kicked into high gear. The U.S. Attorney's Office has the resources to go toe-to-toe with Epstein's legal team.
It should have, but this is precisely where the entire case takes a sharp, unexpected turn.
And it doesn't happen in a courtroom. It happens, as the sources say, behind closed doors.
This is maybe the most disturbing part of that whole 2005 to 2008 period. We're moving from courtroom pressure to backroom deals. It shows that Epstein's influence reached right into the senior levels of the Department of Justice.
How did they do it? How do you alter the path of what seems like an open and shut federal prosecution?
Primarily through direct lobbying of senior federal officials. And we're not talking about just sending a letter. This means personal meetings, often set up by powerful intermediaries.
Who are these intermediaries?
They could be anyone. Former high-ranking government officials, powerful political donors, people who aren't on the legal team but who can get the U.S. attorney on the phone. Their job is to broker a deal outside the normal chain of command.
So the pressure is less about legal arguments and more about political and professional
Oh,
consequence.
absolutely. The implied message is, if you pursue this case to the fullest extent, it could be bad for your office, bad for your career. It's leveraging relationships and shared social circles,
And the sources use this very specific phrase, back-channel communications.
which tells you everything you need to know. It means they were deliberately sidestepping the formal, transparent, evidence-based process.
Because if they went through the formal process,
The evidence for a severe trafficking charge was overwhelming. The back channel was their only way to negotiate a result that completely ignored the evidence.
and in this process, in these secret negotiations, there was major collateral damage. Let's talk about the victims.
Right, because this is where the system didn't just bend, it broke a federal law.
You're talking about the Crime Victims' Rights Act, the CVRA.
Exactly. The CVRA is very clear. It gives victims in federal cases specific mandatory rights. The right to be informed about plea negotiations, and crucially, the right to confer with prosecutors about them,
It's meant to give them a voice.
to ensure their perspective is heard before a deal is cut. Yet, the sources confirm the victims in this case were told nothing, they were not informed, they were not consulted, the deal was done completely in the dark.
They were silenced.
They were silenced and excluded. And that's not just a procedural error, that's a profound secondary injury on top of the original crime.
What's the impact of that denial?
Emotionally, it sends a devastating message. It tells the victims that the justice system is there to protect the powerful, not them. That their pain, their input, is disposable when it comes to making a convenient deal for the government.
So their rights were the first things sacrificed in these back-channel negotiations.
Absolutely. And that tells you who held the power in that room. It wasn't the prosecutors representing the victims, it was Epstein's team, dictating terms that required the government to violate the law.
Which sets a terrifying precedent. If you're powerful enough, you can force the federal government to break its own rules to let you off the hook.
Precisely. It was a complete institutional failure.
And the result of that failure, the end product of all this back-channeling, was this single document, the Non-Prosecution Agreement, the NPA.
The NPA. This is the central mechanism. This is the smoking gun of the whole affair.
And its purpose was simple.
To shield Jeffrey Epstein from any federal charges whatsoever, despite everything the FBI had found.
Let's just put that in context. If he had been prosecuted on those federal sex trafficking charges, what would he have been looking at?
Decades in prison. Mandatory minimums for trafficking minors across state lines are no joke. We could be talking 20 years, 30 years, maybe even life in a high-security federal prison. That was the real legal jeopardy he was in.
And what did the NPA give him instead?
It's a shocking contrast. The NPA funneled everything down to a single, much lesser state charge, solicitation of prostitution.
So it completely minimized the scope of his crimes on paper.
Completely. And instead of decades in federal prison, he got 13 months in a county jail with a work release deal that was so lenient he was out of his cell 6 days a week. It is just an astonishing disparity.
But the NPA did more than just protect Epstein. This might be the most toxic part of the whole deal.
It is. The agreement didn't just grant immunity to him, it granted blanket immunity to any and all unnamed co-conspirators.
Unnamed.
Unnamed. Which means it created a protective shield around his entire network. Anyone who might have facilitated his crimes, procured victims, helped manage the operation, they were all protected from federal prosecution related to this investigation.
So it slammed the door shut on any wider investigation.
It froze it in place. You can't build a larger conspiracy case if you've already given immunity to all the potential conspirators. It destroyed any leverage prosecutors would have had to get lower-level people to flip and testify against others in the network.
It's an institutional cover-up, essentially.
It's a protective blanket thrown over the entire criminal enterprise. And the immediate consequence was that the victims were now totally silenced. Their federal rights had been violated, and now their path to federal justice was permanently blocked by this secret agreement.
And the secrecy is key. The NPA was sealed from public view.
Of course it was, because secrecy served everyone involved. It served Epstein, it served his lawyers, and you have to assume it served the federal officials who signed off on a deal that was so indefensible.
When you look back, the sources describe this NPA as one of the most extraordinary plea deals in modern American legal history. Is that hyperbole?
No, I don't think it is. Because it wasn't really a plea deal. A plea deal is a negotiation based on evidence. This was an institutional surrender based on influence.
It showed that for a certain class of defendant, the normal rules just don't apply.
That's it. Any other person in America facing that mountain of federal evidence would have been facing a swift indictment and a long prison sentence. The NPA proved that if you have enough money and enough connections, you can force the system to create a special set of rules just for you.
So it confirms the existence of a two-tiered system of justice.
It's the clearest example you could possibly find. One set of laws for ordinary people, and another, much more flexible and negotiable set of laws for the hyper-elite. The failure isn't just that Epstein got a light sentence. The failure is that the federal justice system allowed itself to be manipulated into protecting not just him, but his entire network while throwing victims' rights out the window.
Which brings us to the biggest, most difficult question.
Yeah.
Why? Why did the system bend like this? This wasn't an accident. The sources are clear on that. This was a demonstration of how the system is designed to accommodate power.
That's the painful conclusion you have to come to. It wasn't one rogue prosecutor. It was a systemic response. And it was driven by, I think, two things: institutional fear and institutional dependency.
Let's unpack the fear aspect first. What were these powerful federal officials actually afraid of?
Well, they were afraid of a lot. First, political backlash. A case like this with connections to so many powerful people would bring intense, uncomfortable scrutiny from Congress, from the media, from all sides.
They were also afraid for their careers, reputational harm.
Absolutely. Nobody wants to be the prosecutor who gets dragged through a years-long, scorched earth legal battle with a defendant who has unlimited resources to attack your character and your integrity. It's a career killer.
And there's a more subtle fear too, isn't there? The social fear.
Yes, and this is the cultural piece. If you're a senior official in the DOJ, you likely operate in the same elite social circles as Epstein's defenders and associates. To prosecute him fully is to, in a way, attack your own class.
You risk being ostracized, losing connections, jeopardizing that high-paying private sector job you might want after you leave government service.
Exactly. The incentive structure pushes you towards compromise, toward a quiet, clean resolution rather than a messy public fight that makes powerful people uncomfortable.
Which connects directly to the dependency factor, how Epstein had embedded himself within the establishment.
Right. He was brilliant at this. He used his money and philanthropy to make himself seem indispensable. He was a major donor to universities, to research labs, to political campaigns.
All these powerful institutions become dependent on his money.
They do. And so when an investigation starts, those institutions have a vested interest in it going away quietly. They can apply their own subtle pressure back on the justice system.
So prosecuting him becomes a high-cost endeavor for everyone. It risks upsetting donors, disrupting political alliances, and creating a huge mess.
It creates a powerful bias towards self-preservation within the system.
Yeah.
It's easier for everyone if the problem just gets managed.
And all of this is built on top of a fundamental cultural bias.
That's the painful truth at the bottom of it all, the cultural deference that our justice system affords to the elite.
The idea that certain people get the benefit of the doubt just because they're rich and well-connected.
Yes. There's this unspoken assumption that someone so successful, someone who belongs to all the right clubs and knows all the right people, couldn't really be a monster. The presumption of innocence gets warped into a presumption of virtue based on social status.
And that cultural tolerance undermined everything.
It did. It allowed the system to bend, because culturally, our system often respects power more than it respects the principle of equality under the law. The failure in those years wasn't an anomaly. It was the system working exactly as it was vulnerable to working when confronted by that much influence.
So the law was clear. The evidence was clear.
But the will to enforce that law equally was neutralized by money and power. The MTA wasn't a mistake. It was a successful strategy built on exploiting all of those fears and biases we just talked about.
A template for how the powerful can firewall themselves from consequences.
Exactly.
So, to bring this deep dive full circle, that period from 2005 to 2008 was the moment. It was when accountability was completely derailed by influence.
It was.
We've traced this clear chain of failures. You start with a strong local case that gets smothered by resource-rich obstruction,
Which then leads to that successful, behind-the-scenes federal lobbying.
which results in the violation of victims' rights and, ultimately, the creation of that non-prosecution agreement.
And that MPA, it's the monument to this whole failure. It protected Epstein, it gave immunity to his co-conspirators, and it stands as proof of how the justice system bent to the will of wealth and power.
Accountability was basically traded for a quiet life for the people in charge.
It was traded for political and professional expediency, and in doing so, it ensured that the network around Epstein remained intact and totally shielded.
And that leaves us with a really challenging question, one that goes way beyond this one case.
Hmm.
If our justice system allows wealth and connections to bypass clear federal crimes, if it lets secret deals violate the statutory rights of victims, what do we do about it? What mechanisms can possibly restore transparency and trust?
I think that's the fundamental question. How do you build a system that's resilient against this kind of elite influence?
And is it even possible?
I think the answer has to be about identifying those specific points of vulnerability, the back channels, the institutional fears, the cultural deference, and sealing them off. Justice has to be truly blind to wealth and connection, not just claim to be, because until our system confronts its own cultural bias towards the elite, these kinds of failures, they're going to happen again.
If you enjoyed this conversation, please like, subscribe, and share this video. Also, let us know in the comments what really stood out to you in this conversation, and if there's any related topic or new topic that you would like covered in a future video.